Dhanshri, please tell us about yourself.
Good evening, sir. I am a graduate of National Law University, Punjab, of class of 2022. Post my graduation, I worked under the aegis of Advocate Pradeep Rai in the Allahabad High Court, where I worked as a junior advocate. Thereafter, I worked as a legal manager at ICICI Bank.
Yeah. Even in this introduction, you were not clear about the dates or the period. I worked with Pradeep Roy from this to this period. Then I am with ICICI Bank from this to this period. You are now with ICICI, na?
No, sir, I left a couple of months ago.
Oh, oh. Now, please explain what was the nature of work you were doing under Pradeep Roy and after you are joining ICICI. In which one do you say you were involved more legally or your legal knowledge was made use of more?
Right, sir. So while I was working as a junior advocate with Advocate Pradeep Roy, I was involved in the service litigation matters as well as GST matters. So that work primarily pertained with matters coming in from the Central Administrative Tribunal as well as a few matters pertaining to GST. However, my work as a legal manager at ICICI Bank pertained primarily towards security creation transactions, lending transactions, and transaction banking and branch matters that pertain to the legal aspects that the branch officers required. Coming to the third part of the question, where you mentioned where the most legal ingenuity was required from my end, I would say the kind of work that I did with the advocate pertained to the kind of legal aspect that was geared mostly towards the courts. However, while at ICICI Bank, I got to interact with a lot of advocates. However, my work was not geared towards the matters of the court. It was primarily related to documentation. So, in conclusion, I would say something that was to do with law was mostly with the kind of work that I used to do at the High Court, and not as a legal manager at a bank.
But in the interview, I would suggest you are telling you were using your knowledge in banking more. I,
Right, sir.
honestly, your answer, I know that I concur with you. But then, if you give this answer, they will say, then why are you coming to bank? Why should you not continue as a junior and go for higher positions after getting practice? Why are you not confident that you will make a road into that private advocateship? Everybody knows one cannot be a successful person unless he has a very big family behind him to support or before him. So that way, but this type of questions they will ask you, and unless that will be so better talk in favor of the plus points you had in our ICICI bank, so that you say, I am going in connection with that for this one. Of course, you will face a question why you resigned abruptly. Did you resign after writing this exam or before writing this exam?
So the decision to resign from the position of a legal manager at ICICI Bank was after writing this exam, after I was shortlisted for the interview.
Hmm. Acha? And are you married?
No, sir.
What is your father?
So my father used to work in the Ministry of Defense.
Mother?
So my mother teaches in a primary school.
Excellent. Good. So, which office of ICICI were you working?
So I was working in the headquarters, North headquarters of ICICI located in New Delhi.
Oh, is it a place very much far away from your home? So you wanted to get back to your home that made you resign.
Yes, sir, that could be one of the reasons why I had to resign, because my hometown is in Varanasi, Uttar Pradesh, whereas the office that I was working at was in New Delhi.
But invariably, in case we select you, we will also post you in Mumbai or Delhi or Kolkata, etc. Why, in what way will you be continuing with us? Is it that the salary was low for you there?
Sir, I believe there were many reasons as to why I left ICICI. Prime amongst them was, of course, the remuneration package that I used to get there and the kind of exposure that I experienced at the bank. As I mentioned before, the work primarily pertained to legal documentation and very little to do with law. I believe the work at Exim Bank is mostly geared towards syndicate banking arrangements, where the legal knowledge required and the legal team that works at the bank is much more proficient, and the kind of work that and the kind of work and exposure that Exim Bank provides to each of its candidates can is unmatched compared to any private or public sector bank.
Mhm. What was the packet they were paying you in our ICICI?
So the
Pay packet.
remuneration package. So
Hmm.
the remuneration package was such where if the candidate had completed 1 year of one had completed working um uh, in a full time position for 1 financial year, then the bonus and the deferred allowance was paid according to the number of days that the person had worked. So, for example, if the compensation package is such where they're promising 9 lakhs per annum, so out of those 9 lakhs, 2 lakhs were paid at the end of the completion of 1 financial year. So effectively, the take home salary used to be 7 lakhs.
Yeah, because you will not be completing one financial year this year. You will complete only in the next year.
Yes.
That is the problem. Good. I understand that. Good. And you said your role was mainly to deal with documentation and all. In documentation, is it that you people decided it or you had to consult some outside advocate for deciding finalizing the documentation?
So the documentation in the bank was very much an inside job so far as the timelines and um, uh, internal approvals that were required from the bank. So nothing to do with law, very little to do with law. So only so far as the statutory timelines that were given under the Companies Act and SARFAESI Act, those were to be followed as per the legal lending documents. But lending documents and lending transactions were very rarely consulted with the impaneled advocates with the bank. So it was very
Right.
much an inside thing that used to
Yeah,
happen.
because
And
everything is happening based on approved documentation and documents
yes,
which have
sir.
been approved already. Fine.
Yes, sir.
Now, you worked in Delhi. What is the stamp
Yes.
duty for your agreements?
So the stamp duty for agreements in Delhi, given under the Delhi Stamp Act, is for a simple agreement is 300 rupees, and can vary depending on the type and kind of document. For example, if there's a mortgage amount or if there's a security trustee agreement, then 2% of this secure transaction is taken in as a stamp duty. Otherwise, if it's a simple lending document, then 300 rupees is taken in as a stamp duty.
Now, the case of mortgage, which type of mortgage the bank was following? Is it a registered mortgage or equitable mortgage? And what was the procedure followed?
So, with respect to mortgage, the kind of mortgage that the bank would follow was the equitable mortgage, where the title deeds were deposited with the bank. However, the possession and the ownership remained with the debtor itself. The kind of procedure that would follow in such cases was where the bank would require two documents. One would be the memorandum of entry, wherein we would mention everything to do with the details of the property, and the other document was a memorandum of declaration, wherein the debtor would state that the debtor has the right and interest over the mortgaged property and is the rightful owner. And if not, then if it's a leasehold property, then the lease then you take a permission from the owner of the property, stating their consent, and stating that they are in fact the rightful owner of the property, and they have leased the mortgage property to the debtor. So these are the two documents that were taken in by the bank.
Did you come across an incident where a leased property was given as mortgage?
Yes, sir.
Acha, I have not come across. Very good, no problem. So now you told, and then in the equitable mortgage, you said you did not specifically mention about the fact that the document will be handed over to the bank on one day, and the documentation will be taken as if it has been confirmed on the subsequent day. Some such point has to be told, and then what other formalities follow, namely getting them registered with registrar, and what is the stamp duty and the process followed. Can you explain about it?
So, to the best of my knowledge, in case of an equitable mortgage, the stamp duty is not that high, and it's only supposed to be like a loan agreement between the creditor and the debtor. So it is not registered with the sub registrar. So
I'm
that way,
sorry.
the
No, no,
stamp
no.
duty.
I don't know what is happening in ICCA, but nowadays
Okay.
majority of the banks are for you. Please check it up. Majority of the
Um,
banks, they follow a setup that after taking equal mortgage, this document is being registered as a on a notional value with the registrar office, so that the owner cannot sell this property to others, and this charge will be entered in the registrar books. The system you were telling was followed when I was in bank 20 years ago. That was the system. Simply the fellow will come and give the document, execute the confirmation. With that, it is over. And what happened? Many people, they started taking duplicate title deeds and started creating second mortgage, not known as second mortgage. They started creating registered mortgage and availed finance that resulted in banks' securities being affected. I'm surprised how you are familiar with this, how you are not familiar
so
with this.
with respect to creation and registration of charge, that used to happen, and that used to take place separately under the Companies Act. So CHG 1 forms would be filed by either the borrower or the company, or the bank itself, and in that the loan documents would be attached. One of the attachments that was required by the MCA was the loan document, and
I
that being
understand.
the.
What you are telling is registration of charge within 30 days from the date of creation under the Companies Act. That is
Yes,
a
sir.
separate one. And I think now a new concept has come. SARSAI. What is it?
Yes, sir. So SURSA is a central registry under the SARFACI Act, which states the perfection timeline. For example, in a secure transaction, the risk that the debtor runs is the risk of essentially not getting paid. So there are two aspects: one is attachment and the other is perfection. So SURSI deals with the second aspect, which is perfection, which states that there is a public announcement to the effect that a charge is created on a particular asset, and if a bank or a financial institution wants, it can go ahead and enforce their security interests on that particular asset. So the SURSA is a central registry which contains um, uh, every bit of information with respect to any property, or movable or immovable, that is either hypothecated or mortgaged with a financial institution or a bank.
Please note down number one,
Yes, sir.
the procedure for completion of EM, whether it requires any registration with registrar of properties. Note it.
Just a second, sir. Just a second, sir. Yes, sir.
Number two, um, regarding registration of charge under Companies Act, is that to be done and this registration also to be done, or is it sufficient only under Companies Act that is done. Will that do?
Okay, so I'll just check that.
No, no, doesn't matter. You don't have to answer me now. Note it. Next
Yes,
time,
I've noted it.
next time when we meet, we will discuss in detail. Next point, Sir Sai, is it applicable only for limited companies, or is it applicable for partnership firms or proprietary firms, finances also?
Uh, so to my
And
knowledge, it is yes, sir.
yeah, now tell me what is the answer? If you know, you tell me.
So to my knowledge, it is applicable to every entity because the definition of borrower under SARFAESI Act includes partnership firms and body corporates as well.
ओके सरसाई में रजिस्टर करने से और कई जो दूसरा जगह भी रजिस्टर करना है ना क्या? Because or registration under सरसाई will go towards registering in registrar office also. Supposing my property is in Chennai and I avail this finance and it is getting registered under CERSAI, is it necessary for these people to go to the registrar office for registration of this mortgage or not? This is technical angle. This can be
Ye-
known only when you talk to somebody who has been working in the branch or somebody who has had the exposure to this. So far nobody has been able to confirm it definitely to me. That is why I'm asking you. Of course,
So,
this much detail they will not ask in your interview. Tell me.
so I can answer basis my experience in my previous organization. There, in addition to the registration of charge under CERSAI, it is mandated that under the Companies Act under Section 77, the borrower is required to register the charge, and there is a statutory timeline that is to be followed. And if the borrower fails to register the charge with the registrar of companies, then the bank or a financial institution or the creditor can also go ahead and register the charge. And it is absolutely necessary on top of the CERSAI registration that takes place because if if this registration doesn't take place as per the Companies Act, then the creditor's charge will become void against the liquidator. If the company goes into liquidation, then the creditor's charge becomes void. That doesn't mean that the creditor will not have a right to recover its dues. It's just that if the company goes into liquidation, the priority of charge that the creditor may have otherwise had, that is lost if it's not registered under this procedure.
So this aspect I was knowing already. This is not a doubtful thing. Charge registration is a must. I asked about individuals or proprietors, partnerships, and all that. And even here, in the case of limited companies, is it
Yes, sir.
sufficient? It is registered under Register of Joint Stock Companies, or it requires further registration in the books of registrar properties. Any of this is a very complicated issue, but think about it, find out. Now,
Right, sir.
what is your knowledge regarding DRT?
Oh, right, sir. So DRT are specialized tribunals that are debt recovery tribunals that are made under the Recovery and Debts Due to Banks Act 1993. Uh, this tribunal is specifically made for any recovery of dues that are made to the banks. The banks can directly approach the DRT, the tribunal, and get their dues covered within a statutory timeline of 30 days. So the application can be filed in a manner where it can either be an original application or an interlocutory application.
Hmm. I think you are slightly wrong in that you said it is only applicable for banks. Are you sure about it?
So banks and financial institutions.
Uh-huh. By non-banking finance companies also, who can file DRT case? Banks and financial institutions can file original applications with the DRT. The application can be filed by banks or their agent to an authorized through an authorized legal practitioner. What is the procedure for filing of DRT case?
So, in the first instance, the bank or a financial institution can make an application to the tribunal, and
Hmm.
then thereafter, the tribunal will summon the borrower within 30 days. That is the
Hmm.
statutory timeline. And then
Hmm.
thereafter, the borrower will also get a chance to represent itself and file a written statement. And the timeline for that is 30 days again, and an extension can be provided by the tribunal for 15 more days. And thereafter, upon filing of the written statement, the defendant is required to disclose all its properties wherever the banks may have created its charge. And if uh, upon
No,
admission of the
no,
application by the
your,
tribunal,
your answer requires improvement.
right, sir. So this is the essential procedure wherein the defendant, if the application is admitted in the tribunal, then the defendant is required to pay the dues made to the bank within 30 days.
That is all correct. It's all correct.
Yes.
But in the process of filing of case, it is given separately like this. The application is to be submitted in the prescribed format. It can also be filed online through eDRT portal. The application must include the amount of the debt, details of the debtor, and the supporting documentation. The DRT is a quasi judicial body that was established for recovery of debts. DRT's jurisdiction covers all of India except Jammu and Kashmir. So that's why, not that one. I was thinking about, you are not mentioning that eDRT, electronic
Right,
filing of, yeah,
right, sir. Right, sir.
that could have been added. An advocate who is thorough with this must be able to know about that also. I just searched in our Google DRT cases and it tells so many subtopics like debt recovery tribunal, application procedure, standard operating procedure, complete guide, then debt recovery tribunal, that is who are eligible to recover money, like that. So you please go through this also. What is the stamp duty to be paid?
So with respect to uh,
DRT.
so this stamp duty with respect to filing an application is not required, sir.
Mhm. Somewhere I read some 12,000 or maximum of 1,50,000 and all. I think it was given in our material also by some candidate.
So
Mm.
that is with respect to if the defendant or the creditor, the borrower or the creditor intends to file an appeal to the order of the DRT, which will go in the DRAT. So in that case, some amount is to be deposited with the DRAT. So
Here
you should,
I get an answer. DRT fees may vary depending on the amount of debt owed. For example, in Chennai, the fee for a debt of less than rupees 10 lakhs, um, 12,000 rupees, and while the fee for a debt of 30 lakhs is 30,000 rupees. Of course, DRT nowadays we can file only if the recovery is more than 20 lakhs, not less than. पहले तो 10 lakhs था, अभी it has been increased to 20
20 lakhs,
lakhs.
sir.
Yeah.
Yes, sir.
Here there is one site, jsrpogillo.com, Debt Recovery Tribunal court fee chart. There is a court fee chart. Um, Here they are telling about original application 12,000 rupees plus additional fees. Review application 50% of OA fee.
Yes, sir.
Interlocutory application 250. Wakalatnama rupees 5. Appeal against DRT order varies. Perusal of documents 100 per case, something like that. So is I think you may be aware of this link. Anyhow, let me give this link. You are a member of any group, newspaper
Yes, sir. I
groups?
am. Yes, sir.
Which
Yes, sir.
which group you are member? Exim Bank. You are member of Exim Bank group, na?
No, sir. I am a member of Karnataka Bank and Federal Bank and N2 newspapers.
It's a Karnataka. Okay, okay. I am giving it. there.
Right, sir. Right, sir.
In Karnataka group, I have given. Not that it is very important, but फिर भी आप use कर लीजिए उसको. ठीक है?
जी सर. जी सर.
Very good. Now, mm, please tell me what is SURFACE Act procedure to be followed in case of recovery. First, before that, tell me what is NPA, what is the definition of NPA, what are the provisions to be made for NPA, and then what is the procedure for recovery under SURFACE Act.
Right, sir. So NPAs are non-performing assets classified by the banks or financial institutions, which means wherein the borrower has taken uh, the finances or amounts from the bank or a financial institution and has not paid for more than 90 days, and the minimum amount can be 1 lakh, and that if the debts are not paid for a timeline beyond 90 days, those debts are classified as non-performing assets. However, moving on from the second part of the question, which is about SARFACI and the working mechanism under SARFACI, it is given under Section 13 of the SARFACI Act, and there are two aspects to it. One is where there is an enforcement of security interest, wherein the borrower can give a notice wherein the creditor can give a notice to the borrower for 60 days after the bank or a financial institution or the creditor has declared the NPA against the borrower, and thereafter can go ahead and take the possession of the property. So that is enforcement of security interest. However, the second part deals with something a little more complicated, which is about a securitization of the interest. So the bank can go ahead and sell those NPS and or cash or securities to asset reconstruction companies. Thereafter, those asset reconstruction companies can compensate the bank or a financial institution for cash or liquid securities, and then this is a process which is known as securitization, and then the banks can go ahead and write off the NPS which are against the borrower, and thereafter they can recover their debts. So this is the working mechanism under SAFESI.
I see it differently that after the 60 days court notice is given and the borrower is not responding to the satisfaction of the banker, then the bank can take possession of the property. By taking possession of the property, we mean constructive possession or another one. What is that possession called? Nominal,
Physical possession.
no, physical possession, and another one, nominal possession, or that is, you what are the different possessions? One
Um,
minute. There is a particular term for that. Yeah. Just a minute.
yes, sir.
Different types of possession. You must know it as a lawyer.
So I'm aware of physical possession and um, constructive possession.
Different categories of possession. Symbolic possession. That word I was not getting.
Okay,
Symbolic
sir.
possession. The different types of possessions are there. Can you tell me some more possessions names,
So
terminologies?
so I am aware of physical possession and constructive possession.
Yeah, here actual possession or physical, constructive, then joint possession, adverse possession, symbolic possession. Symbolic possession means possession is symbolically transferred through an act, such as handing over keys, sale certificate, etc. Then derivative possession, then de facto possession, de jure possession, settled possession, lawful possession. I am giving this link also to you in that group.
Yes, sir.
This
Yes,
is
sir.
very interesting. So I was under the impression that after this possession is taken, then the banks, they don't, one the one way you say is also okay. The majority way banks, what they do, they give notice under Securitization Act, say in the newspapers and also in the website. I think nowadays there is a website in that all banks are posting. And once that is done, on a particular date, the auction will be done. The electronic auction will be done, and then the recovery will be made. I don't think there is a need for us to go to asset management company unless the property to be brought to sale is a huge one, where we feel it may not be possible for us to get auction people in auction. Do you get my point?
Yes, sir. Yes, sir.
इसका बारे में थोड़ा सोच लीजिए. And around that, if you have had some experience in your ICSEI of taking possession of properties, etc., you can tell about that in the real interview. हमारा जरूरत नहीं है, ठीक है? Please
Okay, sir.
prepare on that. Very good. Best wishes. Today we
No.
have had a lengthy discussion on all these things. Next time, your interview date is 20, this is your second mock, na?
Yes, sir. Yes, sir.
Yeah. So I only point I have omitted is IBC.
Yes,
Please
sir.
make a severe, I mean, a rigorous study about IBC procedures, and you always talk in favor of it. In what way it is helping bankers to recover the monies quickly. उसको prepare कर दीजिए. Otherwise, you
Right.
are answering very, very well. There is no
Thank
need
you, sir.
why you should not be selected, but only hitch will be why did you come out at short notice? What made you think? What in what way were you so very? Uh, it was difficult for you to continue there. कब notice दिया आपने?
So that was in October.
Before the test, na?
Yes, sir.
Ah, I can see it. That's why I asked. So doesn't so you tell the correct reason. I resigned even before writing the test for the reason that I was not getting time to prepare properly with the work in the office, where I have to work from 10 a.m. to 8 p.m. So I thought it should better if I resign. So that's why I resigned. Okay.
Right, sir.
Don't you think this is a better option? Because you are an advocate, you must be able to guide me.
Yes, absolutely.
Yeah.
Right, sir.
Please take care. Best wishes. You did very well. I will select you. But unfortunately, मेरा पास power नहीं है.
Thank you so much,
Ah,
sir. So,
yeah.
I just had one more doubt, where you had mentioned that there is a difference of one day when we make a memorandum of entry for equitable mortgage.
Mm. Yeah, yeah, yeah.
So,
That is
so,
there.
so,
That is there, because initially what I am talking is about 50, 60, 70 years back and all, when the people were taking um, possession same day, they will take a document. Then it was proved by them that stating, I just handed over for the sake of verification of title. And these fellows, they may said, I have given it as mortgage. So such statements were made. So to counter that, this argument was done. This arrangement is being done. That is why you will see in the deposit of title deeds, the date given on the document will be 4th. The deposit would have been made on 3rd or 2nd, like that. Do you get my
yes,
point?
yes, I've noticed that, which is
Yeah.
why I was asking. Yes, sir.
Yeah, that is the reason. See, there were cases where the defendant said, I just handed over to my bank for verification of title. I never gave it as mortgage. ऐसा बोलने लग गया. So to counter that, that is why this written document was also taken in the early years. Otherwise, as per law, there is no need for this written document also. Do you follow?
Yes, sir. Yes, sir.
Yeah, you know
So
it.
it is
Thank
only to rectify it.
Yeah, thank you. Bye bye.
Mhm.
I wish
Thank
you
you so much, sir.
success. I wish you
Thank you.
success. Bye.
Thank you so much, sir. Thank you, sir. Good night, sir. Bye bye.